I'm going to introduce the members of Chambers who are taking part in today's panel in a moment. But before I do, can I take this opportunity to make sure that you are all aware of the new members of Chambers' shipping team? Towards the end of last year, we welcomed James Shirley as a member of Chambers. He has now been joined by Lydia Myers, who has also come to us, having started her career with another set. And we also welcomed Sam Mitchell, who has recently completed his pupillage. That's an introduction to new members of Chambers, but the purpose of today's breakfast is to look at some of the issues which have engaged the market over the last year, and which perhaps look set to do so again in the near future. Of course, 2022 was a volatile year, and 2023 looks likely to be the same. January saw the coming into force of IMO's new rules aimed to reduce carbon shipping emissions by 40% by 2030 and 70% by 2050 compared to 2008 levels. February 2023 will see the 12-month anniversary since a number of ships were detained in Ukraine, with the possibility of claims for CTL under detainment clauses. Now, we cannot sensibly address every theme this morning. However, you should find on your chair the 4th edition of Quadrant Shipping Rule Review with articles from members of Chambers, which will supplement our discussion today. And we will, of course, be organising further events during the year to address specific themes. For today, in our panel discussion, we're going to touch on the following topics. First of all, sanctions. What are the particular problems which have arisen? And do traditional risk allocation clauses such as force majeure provisions provide the answer? Secondly, we're going to head to the Eternal Bliss, where last year the Admiralty Judge and the Court of Appeal took opposing views on the scope of damages recoverable for delay in loading and discharge of the voyage charter. This year it is the turn of the Supreme Court. So we'll think about what they might say. 2022 saw limitation actions back in vogue, especially in the context of incidents involving large or very large container ships. So we'll look to see whether we can already identify any developments in the law and procedure for such actions. And in the same vein, what is the impact of the recent decision in the Thorco lineage on damages recoverable under Article 4, Rule 5 of the Hague-Visby Rules for goods lost or damaged? And then just if we have time, what are the implications of the recent Law Commission proposals for reform of the Arbitration Act in the context of shipping arbitrations? So that's a broad outline of where we're going to go. To lead our discussion, I'm joined by 4 members of Chambers, all true shipping specialists with a wealth of experience, and all of whom are routinely involved in the leading cases. Their full CVs are available on Chambers' website. But by way of introduction, to my immediate left, Poonam Melwani KC, our head of Chambers, and described in this year's Chambers Directory in the following terms. Poonam's humble style, combined with a brilliant brain, determination and hard work, makes her a fantastic advocate and fearsome opponent. To her left, Tom Berg, Shipping Junior of the Year for 2021, described as remarkably articulate and intelligent. Tom is unfazed by being put up against people many years his senior. To my immediate right, Craig Williams, a rising star of the shipping and commercial bar, who is very easy to work with, very bright with a good eye for detail, and led by a good number of the Silks Chambers. And then finally, to on the far right, Stewart Buckingham, unflappable and knowledgeable as he is in practice. He inspires confidence for good reason. He is the calmest of the tip. I feel like I'm doing an introduction as a livery here, but there we go. We anticipate that there will be time for questions at the end. And rather than mess around with a roving mic, we're going to try using an app called Slido. And that will enable you. There should be a little card on all of your seats with details of how you can type in your questions so that I can pick them up and then ask them when we get towards the end. Well, that's enough from me. Poonam, do you want to tell us about sanctions and what's been happening?
So, as a responsible, diligent, but humble shipping and commercial barrister, kicking this event off in front of so many distinguished and, frankly, terrifying colleagues. You'll not be surprised to know that I prepared and wrote my talk weeks ago, honing it for weeks, obviously. And the talk was about sanctions, but focused on, firstly, my practice, so that I could pick it up, and my practice, because there actually haven't been that many interesting decisions in 2022 about sanctions. But then the commercial court threw me a curve. 6 working days ago, on the 27th of January, Mr. Justice Foxton handed down a 31-page judgment on sanctions in Revenue and GTLK. And on the same day, 6 working days ago, Mrs. Justice Cooper handed down a 54-page judgment on sanctions in PJSC, National Bank Trust. I could, of course, have rightly refused to talk about either of those cases. This is an annual review, a review of the shipping cases of 2022. But that would have been childish. So the original carefully posed speech has been torn up, and here we go. But before we get to those cases, let's just get some basics sorted. The sanction regime in the UK following the Russian invasion of Ukraine has 2 central features. Still it down. All assets, also called in the regulation funds, economic resources of a designated person are frozen. No one, not the designated person nor any third party, can deal with them. 2, no person may make available any assets to a designated person. To do either is a criminal offence. Identifying a designated person is easy enough. We've got lists that name the individuals and the entities who are designated. But the problem is that the sanctions apply not just to designated persons, but also to entities which are owned or controlled by designated persons. And of course, control is not simple. It doesn't mean just legal control, but a physical control without legal ability suffices to make the entity good by the sanctions. So, as the sanctions were coming in, and then over the last year, we've seen various attempts by designated persons to divest or appear to divest themselves of control over companies and entities. In the most obvious move, oligarchs transfer the bulk or all of their shareholdings to their wife or to a long-term associate. But the arrangements that the designated persons are engaging in to seek to appear to have divested control have become ever more sophisticated and convoluted, so that it is difficult, if not impossible, to come to any quick decision as to whether control has or has not been relinquished, and therefore whether you are dealing with an actual sanctioned entity or only one which you have cause to suspect.
But is suspicion of the device is enough? Is that relevant?
Well, it can be, and particularly in the 2 cases we're looking at, the banks will not make payments where they have the suspicions. And just to talk about how to recognise the little devices. In July 2022, this is a bit of a mouthful, the UK National Economic Crime Centre, together with Her Majesty's Treasury Office of Financial Sanctions Implementation, known to us all as OFSI, issued a red alert in relation to financial sanctions evasion entitled Typologies, Russian Elites and Enablers. It's a useful document identifying various evasion typologies, including the use of trust arrangements, complex corporate structures, offshore companies, circular ownership structures, shell companies, trusts, various other devices. And the point is that the commercial court, and as I say, the banks, are alive to the use of these devices. So, for example, in the recent Foxton decision of 27th January, the judge described a restructuring that had occurred, done so as to show that no one in the chain was now sanctioned, He described it as being obscure, landlocked entities suddenly interested in maritime adventure, with a number of concerning features. And he said that it was obvious that with those circumstances, no bank would allow payments to be made at risk of breaching sanctions. In fact, the bill was prepared to take judicial notice of the cautious approach of banks and to accept to a summary judgment standard without any banking evidence that banks would not, faced with this restructure, make payments, but would hold them for a considerable period when most. And so the issue with the banks brings us to the two cases, Muir Shipping and the Foxton decision. Muir Shipping was last year. There were 7 COAs where freight was payable in US dollars, and where after the contracts were included, entities that were related to the charterers were put on the sanctions list. One of the debates in the arbitration was would charterers themselves sanction? Touched on how difficult it is to work it out as you're not actually. But what was found by the arbitrators was that, given the links, the banks would not have allowed payment of the freight in US dollars easily, but would have required investigations, which would have meant that charterers would be in breach of their obligation to make timely payment of the freight in US dollars. What happened though was that charterers realized this was going to happen and there was going to be a problem. So they offered to owners to make the payments in euros. Owners would receive them in euros and they'd immediately be converted to US dollars. And charterers offered to make in any currency loss exchange loss. And by doing the payment in euros, there was no problem because you weren't involving US banks that they weren't worried about. There was not going to be a problem with the sanctions stopping the payment. Owners refused this offer. They refused to perform and they cancelled all 7 COAs relying on force majeure clauses. Now, a force majeure event, I'm not going to go into detail, in fact, was found by the arbitrators to have occurred, subject to one proviso. The force majeure clause provided that you could only say force majeure if what had happened was something which could not be overcome by reasonable endeavours. It was held by the arbitrators that since the owners could have accepted charterers offer, taken the money in euros, suffered no detriment, being paid everything else, they could have overcome the problem by reasonable endeavours, and so they could rely on the force majeure clause. Mr. Justice Jacobs at first instance said no. He said the contractual rights to receive payment in US dollars, owners could be expected to accept non-contractual provision. And so the offer of euros could not be relied on as something that owners should have accepted to develop relying on the force majeure clause. Went to the Court of Appeal by 2-1, the arbitrator's decision was reinstated. And the Court of Appeal majority were very keen to keep their decision in narrow confines. They said all they were concerned about was that particular force majeure clause, the particular wording, what reasonable endeavours mean. This wasn't really about contractual performance and non-contractual performance, analogies and mitigation, all irrelevant. We're just concerned with the construction of a clause. And the issue was, could you overcome the event by reasonable endeavours? You could, because there was no detriment if owners had accepted the offer, and in fact, you decided by the arbitrators. I don't have time to discuss the unsatisfactory nature of the majority decision. How do you decide whether some endeavour is reasonable or not without, let's say, considering what are your contractual rights and obligations? It doesn't seem to me you can look at it in a vacuum, as the majority did. And I really don't have time to read the dissenting judgment of that. I get cross on that talking about that. So then we fast forward to Fox. And the first point to note is that he accepted that Muir Shipping does demonstrate more than just the construction of a force majeure clause. He accepted that what it shows is that clauses which are intended to address supervening events may well involve one party accepting performance otherwise than in strict accordance with the contract. So we've now got two cases recognised within the world of sanctions. Very quickly on the Foxton case, payments could not be made into the nominated account designated in the Charter Party because owners had become a sanctions target, and the paying bank would not allow payment to that account, and we touched on the bank's concerns earlier. However, the Charter had another proviso clause, and it said that where a payment could not be made because of owners being a sanctions target, then owners and charterers should cooperate to take all necessary steps to enable payments to be made. Cooperate all necessary steps. That's slightly unusual. Charterers wanted to make a whacking big payment because there was a buyout option. They wanted to make this payment and buy the vessels. So the charterers were saying, we want you owners to nominate a new account as part of your reasonable steps necessary. Nominate a new account. Nominate one which is frozen, which you can't touch. If you nominate one that's frozen, the US banks will allow payment into it. So we can make the payment. We'll have complied with our obligation, and you lot don't have the money to suspected of sanction, and the money's in the frozen account. Helps, and it's just as well. Yes, precisely so. Owners were obliged under that clause, to use equivalent as whatever it was, to nominate a frozen account. He held that payment by someone into a frozen account is contractual performance of your obligation. It doesn't matter once you pay into account that the person can't read it, can't access it. And again, it was on the wording of the clause and the specific nature of the deal that he said reasonable endeavours require the account to be paid. So that's what he would have done, and steps no doubt are taking place as we speak for accounts to be opened and back to perform. Now, there was a special clause, but I have one question for you. Would it be possible for people to argue that the same result would follow under some sort of implied duty of cooperation or an implied term if you cannot make payments and the contract can't be performed because of sanctions years of a bank? It would be said that implied term for owners to nominate a frozen account so that payments can be made and the contract continue owners access to the funds till it's sorted. We'll see. I think it might be being argued in some other cases, and we'll see where that gets to.
But the results you've had in Gravel are potentially startling in themselves. But am I right in thinking you think Cockerell has taken it even further and has moved startling?
Well, no. Mrs. Justice Cockerell has not given us a speech. The argument in front of her was startling, and she rejected it. I'll do this very quickly, but recognising how important a pointer she has given permission to the Court of Appeal. This is PJSB National Bank, where one of the claimant that's supporting, person seeking the money, seeking the judgment, was a designated person claiming sanction. The defendant's argument was that the claimant, the designated bank, could not be allowed to continue with their action, could not be allowed to get a judgment, because the entry by a court of any judgment for a designated person would, in light of the sanction regime, the judgment would itself be unlawful. Ramifications are obvious. A designated person, regardless of how meritorious their claims are, is denied access to a judgment. The courts in this country are not able to do their job and adjudicate. Mrs. Justice Cockerell rejected the argument. And as I say, she's given permission to the Court of Appeal, so we'll see. But very quickly, many different strands were considered. The scheme of sanctions, as it was first developed by the UN in 1999, the later EU regulations, the current ones, close textual analysis and the differences between them and what those differences might or might not mean, because this was all relevant to the big principle of legality, the principle that certain fundamental common law rights, i.e. including the right of access to the courts, will not be treated as curtailed unless they are clearly prohibited, or unless curtailment is clearly authorised by primary legislation. In my last minute, let me just say that the heart of the point was this. Sanctions provides that a person must not make funds or economic resources available to a designated person. During argument, the claimants came to the point where they conceded that a cause of action is an economic resource and that a judgment debt is a fund. So, when the commercial court is adjudicating upon your cause of action and giving you a judgment debt, is it dealing with economic resources and funds? A paragraph 26, Justice Cockrell holds in about a couple of sentences of this very long judgment. No, it's not dealing. She recognises arguable that it is. She recognises that it's arguable that it is, and that the principle of legality trumps and means you don't deprive the right. That's going to go to the Court of Appeal, so we need to watch that space. And I haven't got time, but another point to bear in mind is even if the courts are authorised to give judgments, there may be debates about whether lawyers are in breach of sanctions if they're acting for sanctioned claimants and assisting them getting a judgment.
Well, that's certainly given us all something to think about, particularly given the question as to whether the same approach may or may not apply in arbitration. But before we all reach for the panel, I'm going to move us on to something else. Craig, consequences of delay in loading and discharging a vessel with voyage charter. Some may say that the decision of the Court of Appeal in the Eternal Bliss, and I recognise not everybody in this room will say that, has restored the orthodoxy. Do you agree?
The short answer is yes. The decision has reversed the default position to that which I suspect the majority of the market, at least, if not legal sector, had understood it to be for at least 30 years since the bond. I'm sure the vast majority of people in this room are very familiar with this case. And I know that some people are even more familiar than that. Look at you, Tom, and Simon Rainey KC sat staring at me.
Careful what you say.
But for those of you that are not, it'd be useful to give a short summary. As Mr. Justice Baker himself noted, the case gave rise to an opportunity to resolve a long-standing uncertainty on a point of law of significance within the shipping industry, i.e., what exactly does demurrage liquidate? Is it all losses arising from the breach of the lay-time provision, or is it only certain kinds of losses? If the latter, what type of losses, and how do we know the parameters from the charter party? The orthodoxy prior to the first instance decision, and that which is now returned, at least for the time being, until Mr. Rainey and Mr. Bird appear in the Supreme Court, was that if there was both a separate breach and a claim for a type of loss other than detention, the owners could claim for that additional type of loss, and that is the bond. However, if there was only a single breach, that separate type of loss could not be claimed. The Court of Appeal started by noting that apart from the bond, by which the Court of Appeal was bound, the cases were inconclusive on the question. This is where the uncertainty, as far as the legal world is concerned, arises. The Court of Appeal noted it was impossible to ascertain a ratio on the question one breach or two breach from radio and Arcos, and with some justification criticised the judgment as being so unclear that they could just simply not get a ratio for it. Nevertheless, the vast majority of Lord Justice Mayall's judgment is dedicated to discussing such non-binding and or inconclusive cases. However, ultimately, the Court of Appeal dealt with the matter as one principle. It only spent a few short paragraphs doing so. I'm not going to summarise his decision in the interest of time, but I will say that the Court of Appeal's judgment will be seen as a return to orthodoxy by many in the industry, and also as a victory for charters.
So that kind of raises the question: what do you see the issues like, the principal issues likely to be in the Supreme Court?
My personal view, and I know that Tom and Simon will no doubt disagree with me, is that the Supreme Court will focus first on the aid of certainty and favour the two breaches approach, though possibly for different or at least more limited reasons than the Court of Appeal. As I said, the vast majority of the Court of Appeal's judgment was spent analysing whether there was consensus in the previous case law, with only a few paragraphs analysing the matter as one of principle. I suspect the Supreme Court will find that the starting point is that liquidated damages cover all losses arising from a particular breach, and that the bond was correctly decided. I also suspect that they will re-emphasise, and this is a key point to my mind, that the market's ability to obtain the outcome they decide by amending the clause. There's certainly some parts of the Court of Appeal's decision which seem open to criticism in the Supreme Court. The Court of Appeal sought to minimise, for instance, Mr Justice Devlin's comments in Chandler's that the demurrage rate is presumably the party's estimate of the loss of prospective rate, which the owner is likely to suffer if his ship is delayed beyond the lay days, as being an assumption which, quote, cannot be regarded as having anything like the status of a finding of fact as a general market practice. I mean, this is somewhat ironic, as the Court of Appeal approached the case on the premise that demurrage is negotiated not just as a potential loss of future freight in mind, but other potential losses, which is similarly, given the process by which the case appeared before the court, an assumption rather than based on any evidence. And secondly, the Court of Appeal state that they do not know whether the reason the point that has not arisen in other cases which are in public view is one, because they have been settled on the basis of the bond, or two, the point has simply not arisen. If the latter, the Court of Appeal saying it is support of the issue being rare. If the former, they say whatever the legal archaeologists, to use that term, may say about the point not having been settled. This does not trouble the market. However, this is based entirely on the assumption that these settlements have been concluded in Charter's favour by reference to the bond, when it could just as easily be that, as happens in many areas where you have a helpful judgment or somewhat favourable judgment, Charters have been keen to settle in order to prevent potentially overturning that judgment, at least in certain circumstances, where the factual element can be against them.
So, thank you for the prediction. It's probably, this may be an impossible question, because we don't obviously yet know the answer, but can we foresee any changes in the drafting of charter pass clauses, irrespective of which way the Supreme Court goes?
This rather comes back to the first question. Was the Court of Appeal's decision a return to orthodoxy? If yes, and if the Supreme Court upholds that decision, then one would presume, though those in the audience will know well better than those on this panel, that such a position will already have been factored into the Charter Party agreements. However, there is certainly scope for change in the drafting should the parties choose, irrespective of the outcome. This, after all, is a matter of contract, which is at the will of the parties involved, as recognised by both Mr Justice Baker and Lord Justice Mells. As such, whichever side the Supreme Court comes down on, it is likely that the power will rest with the market. If the Supreme Court finds different types of loss can be claimed for a single breach of the lay time provision, I would expect demurrage provisions in charter parties to explicitly state precisely what type of losses are covered in order to avoid types of disputes alluded to in paragraph 55 of the Court of Appeal's judgment as to whether things like fouling of a hull and consequent delays amount to the type of loss covered by the demurrage provision itself. If the Supreme Court decides that the Court of Appeal was wrong, I would have thought that some owners would try their luck, although it would be dictated by the market, to attempt to explicitly carve out areas where the demurrage provision does not cover and therefore get additional damages that way. However, care will have to be taken when any such provisions are made to the charter parties to try and make sure they're back to back down the chain. And that said, there does not seem to have been a widespread amendments following the bond. So I would err on the side that if the Supreme Court was to uphold the Court of Appeal's decision, then as much as owners might want it, they may find it difficult to get the amendments to carve out certain provisions.
Thank you. Thank you, Craig. So that you've explored the drafting of clauses in voyage charters. There's been another recent decision that may have impact on what is defined as loss and damage of goods, what is recoverable. Tom, do you just want to tell us a little bit about the decision in the Thorpe lineage?
Yes, before I do. I don't share.
Go for it.
Nor do I want to steal my own or Simon's thunder. Because you can watch the argument live before the Supreme Court in due course. But what I would say is I think the central problem with the Court of Appeals judgments, as I read it, is that the focus on demurrage clauses as if they were just generic liquidated damages clauses of the type that one finds in construction clauses, and a failure really to grapple with what demurrage means as a maritime concept. And it leads them to the surprising, and in my view, erroneous conclusion that demurrage, daily rates designed to compensate the ship owner for lost frames, is also intending to compensate the ship owner for cargo claim liabilities, and in this case, a cargo claim liability of over $1 million. So I'm much more optimistic about the
Episode 2.
Neutrally put.
Anyway, onto the Thorco lineage, a case relatively hot off the press, handed down in January. Another good advert, like the Eternal Bliss, for the use of Section 45 of the Arbitration Act. The parties decided in this case to ask the court to determine a point of law that had arisen in the course of an arbitration. And the case is about the limit of liability in Article 4, Rule 5A of the Hague-Visby Rules, where there's a situation of physical and economic damage to cargo. Article 4.5a limits the carrier's liability for loss or damage to or in connection with the goods by reference to the hire of two alternative figures, 66.67 SDR per packaging unit or 2 SDR per kilogram of gross weight of, and these are the key words, the goods lost or damaged. Now, the central issue in this case concerned the application of that limit where part of a cargo suffers some minor physical damage, but an economic loss is suffered in respect of the whole cargo. And the question is the economic loss limited by reference to the weight of the whole cargo, just the physically damaged cargo, or is it unlimited? Now, the facts of the case. It arose from the grounding of a bulk carrier in the Thorco lineage. And the claimant was the owner of a cargo of zinc calcine on board the vessel. Following the grounding, Salvors refloated the vessel, but had a lien on the cargo in respect of the cargo interest liability for salvage remuneration. That was subsequently settled for about $7 million. A small part of the cargo was physically damaged in the refloating efforts, causing additional losses of approximately $300,000. Now, the carrier, relying on Article 4.5, argued that its liability for all of the losses, so the $7 million salvage remuneration and the $300,000 physical damage, all the losses was limited by reference to the weight of the small quantity of cargo of which it suffered physical damage. And in support of that contention, the carrier relied on a 2008 decision of Mr. Justice Burton called the Limnos, in which he had held that the word "the goods lost or damaged" in the limit only encompass goods which are physically lost or damaged. So that where an incident causes limited physical damage, but substantial consequential economic losses, the carrier can limit its liability by reference to the weight of only the cargo physically damaged. And in terms of the figures, if that decision was right, the carrier in this case could limit its liability for a $7.5 million claim to just $800,000. So it was quite a valuable points to put to the court under Section 45. The judge, Sir Nigel Tier, sitting as a deputy, declined to follow the analysis of Mr. Justice Burton in the Limnos, preferring the view that the goods which suffer a diminution in value are lost or damaged for the purposes of the limit. And that includes a diminished market value, a liability to a third party, such as salvors, or a requirement to transship or incur other costs. In other words, lost or damaged goods means goods lost or damaged physically or economically. The judge went on to say that even if the decision in the Limnos was correct, he would have held that the entire cargo in this case was physically damaged because the salvors maritime lien had the effect of damaging the claimant's proprietary or possessory title to the goods. And in support of that alternative dictum, he said that he was following Mr. Justice Sheen in a case of Raven Merchant, and also a recent Australian case, Beacon Jahan.
We don't have time to explore all the aspects of that reason, but in his 5-minute briefing on the case, John Russell KC has described the Limnos as being anomalous and suggested that Sir Nigel Tier's reasoning is to be preferred. What are your views on that?
I agree that the Limnos was wrongly decided. It was a curious decision for a number of reasons. First, the corollary of the Limnos was that claims for pure economic loss, such as delay claims, were not subject to any limit at all under the Hague-Fisby rules, which would seem contrary to the purpose of those rules, which were intended to limit economic losses arising in connection with the goods. And secondly, the Limnos gave rise to a stark anomaly, which is that if there was a small amount of physical damage, as in the Thorco lineage case, the carrier's liability for both the physical and economic losses in connection with the whole cargo would fall to be limited by reference to the weight of the physically damaged cargo. And the upshot was that the presence or absence of a small quantity of physical damage could lead to results at either end of the extreme. Sir Nigel Tier's decision avoids this anomaly and is more consistent, in my view, with the language and purpose of the law. However, I'm not at all convinced by the judge's alternative ground for the decision, the effect that the imposition of a salvage lien constitutes physical damage to the goods. In my view, that's a counterintuitive and unnatural reading of the word physical damage. And I don't think the authorities cited by the judge support the
And that would be a consequence of two, because that would be the basis of founding an action, because it's not pure economic loss, it's categorised as physical damage, which is not something the judge, I think, had in mind. When
it wasn't something the judge had, though that was one of the points that was discussed in the Australian decision that I mentioned, the Canada. But you're absolutely right. That finding would have wider ramifications, particularly as regards to
But presumably it have also wider ramifications in terms of the construction of potentially consequential loss rules of what falls within the meaning of consequential loss. Or is the decision really focused only on the Hague-Fisby rules?
My prediction is that it's going to have a few ramifications outside the context of the Hague rules. And that's because whilst the judge found that loss or damage included economic losses, I think that one of the reasons for that is that the words at the beginning of the limits of liability are broadly expansive and refer not only to loss or damage, but also to damage in connection with the goods. I also think that because he was construing an international convention and the purpose of that convention was to provide a limit that applied to all types of losses, that guided the analysis too. So I suspect that judges We want to place too much weight on this decision when considering ordinary commercial contracts. Okay.
I'm going to leave it there then. Thank you, Tom, because that's limitation under his views. Stewart, we've got, I think, a number of limitation actions occupying simply a lot of the court's time at the moment, and at least two of them are in the context of container vessels. Are there going to be any interesting aspects that we see arising out of these actions?
Well, I think if you ask me in any other year what is interesting is happening in the world of limitation, the answer would be nothing.
Stuart, lean forward a bit. When I was at the back, I'm struggling to hear. So shout if you can't hear, because I can hear.
The answer would be nothing. But as Nigel indicates, we are in the unusual situation where we have at least three significant limitation actions going through the Admiralty Court. We have the Familiar, we have the Merce Conab, and most recently, the Ever Given. And they're all at slightly different stages of progress. So in the later ones, you can look at what's happening in the earlier ones and hopefully take some guidance for that. And they raise lots of issues which haven't necessarily been grappled with, at least not for quite a long time, because limitation proceedings on a scale are few and far between. But like London buses on strike, when they come, they can be numbers. And there's three particular issues I was going to mention today. First, in relation to timeline. Now, the way in which limitation works, as I know many of you will know, because I see familiar faces who are involved in these limitation proceedings. The way in which it works is the fund is set up, and then claims are invited to be made against the fund by lodging a certificate on the ADM 20. Sometimes that is lodged together with a statement of claim which provides more detail, but the statutory form is a particular thing. And there's an issue about whether or not lodging that form against the fund also has the result of stopping time in relation to the underlying substantive claim. Now, that is not a question which has been addressed in any previous case. It's not particularly addressed in the textbooks either. And it's a question which obviously has important practical ramifications. Because if you're a cargo claimant against the limitation, you need to know whether or not, in addition to lodging your claim against the fund, you need to issue proceedings in the right forum to preserve your liability claim. And that forum might be arbitration, it might be proceedings elsewhere in England, or it might be a foreign court. Now, that question, as I understand it, is a live one, potentially a live one, in the Merce Conab limitation proceedings. To the extent, I think, that the Admiralty judge in an earlier hearing indicated that if the party wanted that to be a preliminary issue, then it could be. Whether or not that will happen is a question I don't know the answer to, but some here may have a better view. But also, this is the wrinkle, that in a subsequent CMC, I understand that the Admiralty judge indicated or showed his hand, perhaps, on what he thought the answer was to that question, and indicated, over to a non-binding, that the issue of an ADM 20 probably wasn't the issue of legal proceedings from which he would follow that there probably wasn't sufficient to protect time.
Was or wasn't?
Well, wasn't sufficient to protect time. And that, I think, leads to three practical consequences. The first, obviously, is in order to be sure that you have protected your liability claim, you need to issue proceedings or preserve time for agreement, as well as issuing your claim against the fund. Secondly, there's a trap here, I think, for the unwary, because although sophisticated lawyers in London would appreciate the potential problem, many claimants against limitation funds around the world will not be instructing London lawyers and won't necessarily be alive to this problem. So, trap for the unwary if you're not a sophisticated London lawyer. And thirdly, then there's a practical question here, because traditionally the way in which limitation has operated is that the limitation action will deal with the limitation issues. Issues like, is there a right to limit? If so, what is the amount of limitation fund? And then it will deal with the practical questions of lodging the claims against the fund and then the mechanics of distribution. But there's no reason in principle why the limitation fund can't also deal with liability issues. And I think in the worst case, that is something that might happen. And to an extent, it has to be by agreements. If that can happen, it offers obvious potential benefits in saving time and costs. Because, for instance, you're going to have common issues of facts, common issues of law, which can be determined in one go once ruled by the limitation judge in the London action, without having to try those issues separately and perhaps repeatedly in arbitrations and litigation in other parts of the world.
Yeah, that obviously requires a great deal of cooperation between the parties, and really just not merely between claimants and defendants, but also among defendants. But are there any other points in which you might need to just focus on?
Well, I think so. For just picking up on the need for cooperation, of course, is absolutely vital. What I can say from my experience in Poonam and the appeals is that there is a strong degree of sensible cooperation in London between solicitors. And that has shown significant benefits because it supports the process. It avoids unnecessary applications to the court. And we would say, I think that is happening, which is an advantage about our system here. But the second issue I mentioned is in relation to the Flaminia. In a recent judgment of the Admiralty judge in November last year. And it relates to the question, what is within limitation and what isn't within limitation. And in that case, there was an explosion of cargo in one of the ship's tanks. And that led to fire, and the fire led to damage to other cargo, but also to the ship. And the owner of the ship is therefore claiming against the charterer for damage to his ship. And the context in which that claim took place is that a claim by the owner of a ship against the charterer in respect of damage to the ship is not a claim subject to limitation. And it's only claims for loss or damage to property other than the ship that is limitable under Article 2.1 of the Convention. And that was held by the Court of Appeal in CMA Jakarta as long ago as 2004, through domains by the Supreme Court in the Ocean Division. Now, in India, Jakarta obviously needed to find a way around them and came up with the rather inventive argument that the owner's claim for damage to the ship was a claim for damage which was itself consequential on damage to other property, namely the cargo which exploded. The Admiralty judge was having none of that and rejected the argument as, in effect, artificial, I think. So it remains the case that a charterer cannot rely on limitation in respect of a claim by the owner for damage to his ship. And you cannot circumvent by trying to redefine the nature of the damage as damage consequential on property damage.
To mark the 25th anniversary of the 96 Act, the Law Commission has reviewed it. The consultation was published in September and closed in December. And the aim is to publish its final recommendation by mid-2023. Various reforms have been floated, but who knows what the key proposals are in terms of summary procedures.
Summary procedures, so there's no explicit power in arbitration for arbitrators to chuck the case out, a standard or whatever I call what I call fashionable summary judgment way. And there is a proposal in the Commission's report to have a summary procedure, and I think the test is no real prospect of success. That claim that defence has no real prospect of That some arbitration parties are very this because they think it's not compatible with the arbitration formula, which is in effect here the parties dispute. They think it's inappropriate. I think we really ought to have it. There's far too much delay and far too much wasted costs on rubbish quotes in arbitration, and a summary process that is of that and should be implemented.
Thank you. Craig,
Section 67 jurisdiction challenges. What's happening there?
Well, jurisdiction challenges have always been unsatisfactory. The respondent has two bites of the cherry. Firstly, they get to have a go in front of the arbitrators. Secondly, they get a de novo challenge in front of the court, which basically means that the first go in front of the tribunal carries no weight. It's just a dress rehearsal to get yourself some practice before you appear before the court. The proposal is that where one, the party has participated in the arbitration proceedings, and two, has objected to the jurisdiction of the tribunal, and three, the tribunal has ruled on the jurisdiction in an award, any subsequent challenge under Section 67 before the court should be by way of an appeal, not a rehearing. This would mean that the court hearing would be limited to a view of the decision of the tribunal. There would not ordinarily be oral evidence or new evidence before the tribunal which could be adduced at that stage. There is a question, to my mind at least, as to whether this reform is really necessary. Section 67 is only invoked in a tiny percentage of cases and is very rarely successful. The Commercial Court has also already taken steps to weed out frivolous applications, whether by summary procedure or by cross consequences. But not only is there a question about whether the proposal is necessary, there's also a little bit of a backlash to the proposal and a bit of controversy surrounding it on the basis of the idea that the tribunal cannot confer on itself jurisdiction which it would not otherwise have, which is said to mean that the court should always be able to consider the matter again afresh.
Thank you, Craig. And obviously we see far more Section 69 than Section 7 challenges. Stewart, are there any proposals in relation to Section 69 regime?
Well, with Section 69, it involves this balance between, on the one hand, the understandable desire to get decisions which are properly based on correct legal analysis, but on the other hand, the need for finality, recognising arbitrations need to have the leeway to get it wrong, essentially. And there are strong evidence on both sides. The debate was some want to make 69 mandatory so that you can't contract out of it. And there are some which need to abolish it so that there is finality in every case. The Law Commission came to this decision. They say it's a defensible compromise between securing the finality of arbitral awards and ensuring that blatant errors of law are corrected. So they say, let's stick with the status quo, which I must say, from my point of view, is the right answer, because although we see a lot of Section 69 applications being made, or at least applications for permission, they very rarely succeed. Maybe that's just mine.
I don't think you're alone in this, Tom, just wrap it up and tell us what else we know about.
Yeah, there are various other proposals. I don't think they're quite as pertinent to shipping lawyers. But three, just to draw attention to. First, the Law Commission looked at confidentiality and considered whether there needed to be something express written in the Act. It decided on balance that the answer was no. In doing so, it made reference to a 2018 survey, which found, surprisingly, in one sense, that confidentiality only ranks the fifth most valuable characteristic of arbitration to respondents, behind enforceability of awards, avoiding specific national courts, flexibility, and the ability to select arbitrators. Another area that the Commission looked at was arbitrator independence and disclosures. That is something that I'm sure we've all come across, particularly in chain back-to-back charter party disputes, where one arbitrator or possibly the whole panel are acting in related parts of the dispute. What the Law Commission has done is effectively to propose codifying the Supreme Court's decision in the Halliburton and Chubb case. In that case, the court held that if there are circumstances known to the arbitrator which would give rise to justifiable doubts as to their impartiality, then the arbitrator should decline the appointment. But if there are circumstances known to the arbitrator which might reasonably give rise to doubts as to their impartiality, these should be disclosed. It was felt that prompt disclosure is itself a demonstration of the arbitrator's impartiality. Finally, discrimination. There's nothing in the current Arbitration Act requiring that the appointment of an arbitrator not discriminate on the grounds of protected characteristics. And the Law Commission has proposed that any agreement between the nations and the arbitrator's protected characteristics should be unenforceable unless in the context of that arbitration, requiring the arbitrator to have that protected characteristic is a proportionate means of achieving a legitimate aim. And this may be a fitting time to weed out an old chauvinist arbitration clause that one occasionally encounters that the disputes be referred to commercial aim. That might be
interpretive magic. Ladies and gentlemen, thank you. Well, first of all, thank you to my co-panelists for their answers to the various questions that I've thrown at during the course of this morning. But mainly a huge thank you to you for taking the time to come along and for remaining so attentive throughout. That is the end of the session. Obviously, if you have any questions that we haven't answered or you'd like to come and put to us, we will be around for a little bit, so please feel free to come and have a chat. Thank you very much.